I'm hoping we'll be able to have some legal analysis for you with Alton Hart. He's with the Department of Procedural Law at the University of Johannesburg, just to help you and I make sense of what has just taken place and, of course, what the implications moving forward are. But if you've just joined us, the breaking news at this hour is that the ANC has failed in its bid to try and remove the MK party from the ballot box. All right, let's make sense of this for you in layman's terms if we can. Bring in Alton Hart, an attorney, as I mentioned, with the Department of Procedural Law at the University of Johannesburg, and joins us now via our video link. Alton Hart, it's great to see you and speak to you as always. Thanks very much indeed for making time. It seems like a triple blow against the ANC.
No, indeed so. And for me, the judgment was well set out. The judge started with condemnation, going into the points in limine with jurisdiction, and then the merit. So any person on the street can understand exactly what the ANC failed to prove and can understand this judgment.
Yeah, let's go through it via piecemeal if we can. Condemnation is a term that you understand. Perhaps the person watching at home might not really understand what that means. In my mind, it was this question around delay. Was the ANC justified in waiting so long before bringing this matter to court? What did the judges find?
No, the judges found that there was an unreasonable delay. They had no excuse for sitting and dilly-dallying so long and actually approaching the Electoral Commission and as well as the court in saying, we want you to review this. And this is coupled with, and I think the judge, when she talked about the condemnation, she touched on the jurisdiction issue, because it seems like they were trying to bring this to a court where they have not exhausted, and this is the word we normally use, you must first exhaust the internal remedies that's in the Electoral Commission, in the Electoral Act, before you want to jump outside to run to court and say, listen, your court, I want you now to intervene. And she unpacked it very nicely, coming from the condemnation, saying, you had time, you sat so long with your legal representatives, they should or ought to have known that the clock is ticking, and yet you guys were too easy to go on holiday rather than bringing something to court that is urgent, that you see there's no other way if the court, if this decision stands, that you'll find redress, yet you waited so long. And she brought it nicely into the jurisdiction part, where she said also, coming to this court now, you don't have jurisdiction because you had to go first through the Electoral Commission, the internal dispute resolution procedures. And I think there is where she actually hooked condemnation very nicely to say, you don't have an excuse for taking so long in actually bringing this decision before this court to decide on issues that you feel there's no other form of redress that you can get other than coming to this court at this late hour.
Yeah, we're making sense of all of this with our guest at this hour, Alton Hart, who's with the Department of Procedural Law at the University of Johannesburg, and was listening in to everything that was said and helps us now make sense of what the way forward is. And Alton, before we took a moment there just to listen to the reaction from the MK party, we were still speaking about this issue of coordination, I beg your pardon, and how long it took the ANC to take this matter to court. The other question was around jurisdiction. Is the ANC's framing of this right for the court in which they wanted this matter to be ventilated?
I don't think the ANC structured its application properly, because the first thing is that in one aspect, and this now also speaks to the merit, because one side they're telling the Electoral Court should have read this thing, the Electoral Act, very wide to actually make a provision for their application. And on the other side, then they say the Electoral Commission should have read this thing very narrowly to say that it doesn't make provision for supplementation. And that is where you cannot say use a wide interpretation in this side of the legislation, and in the very same piece of legislation, now it must be interpreted narrowly. If you read it, interpretation of statutes tells you that you have to read it within the context, and you can't sort of have limit it. And the ANC was trying to sort of have make the act now tailor fit their application. And on all fronts, I just feel like they have not put a good case before court. They have not shown a good and solid excuse why they took so long in actually bringing this application to court.
So we've spoken about issues to do with the delay, matters of jurisdiction, and then now it comes to the merits of this case. The ANC, of course, had argued that the Deputy Chief Electoral Officer, Mawethu Mosri, erred by actually registering the MK party using a supplemented application. I've just found out from the court ruling itself that the issue, in fact, was that it seems that there was a discrepancy with the signatures of the MK party when they first made the application. The IEC sent it back, they made amendments, and it's through that amended application, if you like, that the MK party was registered. What's your take around how the court actually went around dealing with this, keeping in mind, of course, that it was also a blow for the ANC?
No, I think the court dealt very well with the merits in saying to the ANC in this regard to say, listen, yeah, you saying that the Electoral Act doesn't make provision for the supplementation of a application. And here you want now the court to actually read the Electoral Act in a narrow sense to say, because the word supplementing or amending is not in there, the DCO could not have changed or deal with an amended application. That's internal processes. You can't say, as and I said, I alluded to this earlier, in one side they said the court must interpret the Electoral Act very widely in how they read it to actually make sure that they are given condemnation. But on this other side, they want the court to now read the act very narrowly. And that cannot be. You can't read legislation piecemeal. You have to read it in the context. And I say that the courts, in looking at that, to say that although the word is not explicitly stated there, that they can look at, they made the MK organization aware that there is a defect or a discrepancy or something that's worrying to us in considering your application. And they then allowed them to amend, bring supplementation, and based on that, read with the old application, they read it together and say, now we are satisfied that you are meeting the Electoral Act requirements. So there's nothing untoward how the deputy chairperson went about doing and considering and actually registering the MK party. And I think the court was alert and woke to this situation where the ANC tried to exploit the court to say, read it in a very narrow interpretation and not say, okay, let's read it in the full context of the legislation, also looking at interest of justice and also in terms of the elections, in terms of the constitution, to say that it must purport the spirit of the people of that specific organization balanced against your rights. So I think the court did a stern job in how they dissected the ANC's argument and saying, but you are wrong in how you approach this court and what you want this court to do.
Yeah, so put differently, Alton Hart, I mean, the court is essentially saying here that just because the law doesn't make any comment on a supplemented application, it doesn't necessarily mean that that kind of application cannot be acceptable to the IEC.
Yes, indeed. Just like you say there, although the law doesn't say, but I mean, the deputy chairperson has a discretion, because when they look at these things, they've got discretions as to how they interpret. And law is always about interpretation. And I mean, they've even come and articulated very well. There was other political parties that also amended their initial applications, and they considered it and they registered the parties. So why would we treat MK differently? Not because now MK is fighting with the ANC, we should treat it differently. They say we're going to still be consistent in how we apply the law, to say that we allowed amendments in the past, so we're going to allow it in the future. Obviously, the ANC has got the right to appeal the decision of this Electoral Court, going to another court of higher status to say, listen, yeah, I think the court misdirected itself. They do have that right, but obviously for me, I feel like the two judges did a very concise job in giving us the truncated version of the judgment, but zooming into the issues to make us understand exactly how they went through the thought process, coming to this conclusion that they came to.
Yeah, you know, as you're speaking now, we're still seeing visuals of the celebrations taking place outside court, and I wonder if we can bring them up. There they are, MK party supporters, well after the judgment, celebrating that victory in this first round, if you like, of their litigation against the party from which this organization is considered a breakaway. That's the ANC. The Electoral Court has just ruled, of course, around the issue of them having had registered through a supplemented application, and tomorrow we're likely to hear of a different matter involving, if you like, the patent question. Who owns the identity of uMkhonto weSizwe? And these, of course, are related but separate issues, Alton Hart. And I wonder to what extent you reckon judges in the High Court in Durban are watching what judges in this particular sitting had to say?
No, indeed, they will definitely watch it, and especially because the media is doing so great and actually making sure that all of us is kept in the loop as to what is happening in the one court, so that we can actually be, when we do look at a decision, we apply rationality to it. And for me, it's like, if you look at the application that's going to play out tomorrow in Durban, the ANC said that the MK belongs to them. But if you go into the history of MK itself, MK consisted of UDF, a lot of organizations that came together, especially and the ANC, they made uMkhonto weSizwe. So uMkhonto weSizwe was never part of the ANC, although they claim it. They say uMkhonto weSizwe belongs to the people, but it belongs to the ANC. Not everybody belongs to the ANC. So for me, uMkhonto weSizwe was the umbrella body that had all these, the Indian Congress, the Colored Congress, all these people kicked in to form uMkhonto weSizwe. So you cannot say now that this belongs to the ANC alone. And I think that's where the better lines will be drawn, to say uMkhonto weSizwe was the umbrella body for all these organizations to come together to say, we're going to fight the apartheid regime, and not necessarily to say that it was just a sub-wing of the ANC that was fighting. And that's not my understanding of how uMkhonto weSizwe was also started. So I think a lot will develop around that, and arguments will be around that, to say that ANC most probably form part of the uMkhonto weSizwe, but them banning uMkhonto weSizwe said, like, we're distancing ourselves from uMkhonto weSizwe. Now uMkhonto weSizwe said, we'll stand on our own because you are distancing yourself from us, you've banned us, so we run on our own. So I think, and the thing is, like, when you want to claim intellectual property, you should have registered it. They have lawyers, the lawyers should have advised them, and I think also they might come there to saying who is the registered owner. But I think the ANC again tomorrow should be failing in saying MK belongs to the ANC only, because that is not what history tells us.
Okay, I was going to ask what you reckon is likely to happen, but I suppose you're feeling very confident about that. But related to that, Alton, I mean, people who've covered a couple of elections in this country would be going through a deja vu moment tomorrow, because the MK party is not the first breakaway organization from the ANC that is facing litigation around its identity. You know, when COPE was established, there were real questions about whether or not the Congress of the People can be co-opted by a different organization that is competing against the African National Congress. And even then, the ANC lost. So to what extent would that kind of jurisprudence, do you think, have a bearing on how the ANC stands in the trial tomorrow in Durban?
Now, obviously, if one looks at what happened in the case between COPE and the ANC, I think the people who's arguing on behalf of the uMkhonto weSizwe party, the MKP, they will go down that route, specifically on using the COPE judgment as their backbone for raising or opposing what the ANC is trying to do. And the ANC will have to now come up with alternative strategies to show that uMkhonto weSizwe is a trademark that belongs to the ANC, and I feel that they will have a tough task to prove that, as I said earlier, because uMkhonto weSizwe was a conglomerate of different organizations which represented the Indians, the colored, the black, and some other parts of, even some Asian parts of our communities, that came together and say, we're going to fight the regime. So it will be very difficult for them to say now, this thing that they claim belongs only to the ANC, because not all people in South Africa belongs to the ANC. So you can't say something that belonged to the people now suddenly only belongs to a select few. So I think that's where the battle lines will be drawn.
Absolutely. Well, Alton Hart, thank you for your time, analysis and patience as we make sense of this moment. Of course, plenty of reactions still ahead for us, given just how massive, if you like, this particular ruling has been in the form of a blow against the ANC. Alton Hart is an attorney with the Department of Procedural Law at the University of Johannesburg.